So I would not
Understand what you're charged with in this case.
why would I be charged with something I've never done? I'm not even supposed to be in here for the last 3 months because
All right.
disturbing the peace. I was on that side of a perimeter where there's no
Sir, I don't want you saying
installation. I never,
about the, sir, I don't want you saying anything about the case. I just,
never did.
I need you to know whether the charges you believe are legitimate or not. I need you to understand what you're charged with.
No, you not understand what I'm charged with.
You don't understand, sir?
Charged with it.
Are you telling me you don't understand what you're charged with? Versus de jure Bond Sanders.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Bond Sanders. State your name for the record, please, sir.
De jure Bond Sanders.
Your Honor, I am asking to set this case for final settlement conference, and Mr. Bond Sanders would also like me to address bond.
Jury final settlement conference will be set October 7th, 2026, 9 a.m. Jury selection if necessary, August 10th, 2026 at 8:30. Both of those proceedings are in person as to bond.
Your Honor, Mr. Bond Sanders is asking to be released to Salvation Army in Monroe. He was trying to work this out prior to being incarcerated. Salvation Army Monroe Core Community Center on First Street in Monroe. It is a Salvation Army, and they also have substance abuse treatment there. He's asking to be released on a PR bond and a GPS tether to that location. We just discussed this morning. I'm happy to provide an order to the people, or whatever needs to happen for this to occur if the people are open to it.
He wants to go to a treatment center.
Correct. Yes.
People have an objection?
Apologize, Your Honor. I'm trying to get a little bit of familiarity here. Where is the facility for treatment?
Monroe?
It's the Salvation Army in Monroe. He says that he was trying to work that out prior to being in custody, and Miss Cannon was also assisting with that. I will be honest with the court and people. I haven't reached out to them. We just talked about it, but he's hoping to be released there and is willing to be placed on a GPS tether.
Well, I guess the best way to deal with that is once you get the information, talk to the prosecutor. If you can agree on something, then we'll deal with it. If not, I'll deal with it at final settlement conference.
I can do that.
All right.
And Your Honor,
Thank
I think
you.
the court said October 7th. The court meant August 7th for final settlement, correct?
Yes. Did I
Thank
say
you very
October?
much.
Yes, I meant August 7th.
Thank you.
Thank you. Court calls the case of People versus Aaron Burrows.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Burrows. Who is approaching? Mr. Burrows, state your name for the record.
Aaron Burrows.
All right. I have before me a plea form that indicates that the defendant would be pleading to the charge of allowing an ineligible driver to operate a motor vehicle. That's a 90-day offense. 90-day, $100 fine misdemeanor. And that upon a successful plea to that charge, that being count 2, count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
That's correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Aaron Burrows.
Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court cost. Do you understand that?
I do.
Understanding that, still wish to plead guilty
I do.
to that charge? How do you?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I correct.
Signed an advice of rights form, correct?
I did.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I've been informed.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
of your own free will.
I am.
and because you believe that you are indeed guilty of this offense?
Correct.
On the date of November, January 30th, 2026, at the location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
I did.
You allow someone who was otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
I did.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Anything you or your counsel want to say before court imposes sentence?
No.
No, Your Honor.
How long has he been in?
Probably 3 weeks, 2 weeks or so. About the end of June.
Thinks about 3 weeks, Your Honor. I don't know off the top of my head. I
Does
can,
he have something else holding him? Is
yes.
that what it is? Fines and costs state minimum of $125, and you've been in about 21 days or so?
Correct.
Well, those are 90 days jail. Credit 21. Balance suspended. All right. Thank you. Pardon? So, court calls case People versus Devon Julia Martinez.
Township. And Edward Drukas on behalf of Ms. Martinez in 2108.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Martinez in the other case.
Mr. Martinez, can you state your name, please?
Evan Julia?
We are tracking her felony matters that are pending. Those were adjourned till the 27th of this month,
Till the 27th.
to the 27th. So I was looking to adjourn. And I
After that.
someday.
Adjourn both these matters to then August 5th, 2026, 9 a.m.
Thank you.
Bond will continue.
Your Honor, my client did my own me make a brief bond request.
Go ahead.
I do understand that, and Mr. Lucas may be able to confirm this, that they are trying to work out a resolution in the felony court that involves some form of treatment. So Ms. Martinez would just want to ask the court to consider a release of treatment on these files. So if they do work something out here, that these cases will not inhibit her from going to treatment. I understand the court would like me to file a written order. I just wanted to make the request on the record.
For release to treatment,
Yes.
That would be,
will she complete it this time or is she gonna
Yes.
take off?
Absolutely. No questions. No questions about it. Yes. Absolutely.
If you would like a written order, I understand.
Why don't we look at her failure to appear record and let the prosecutor look at it? And then if the two of you can agree, then I would sign that order. But I'm a bit reluctant to do so because she kind of gets released, takes off, and we don't see her for a while.
appreciate that consideration, Your Honor. Thank
All right, thank you. Bond will continue at this time. Court does call the case People versus Spencer Rassick.
Ashley Feltus for the people.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Spencer Rest. State your name.
Spencer Rasek.
Thank you.
Your Honor, I believe we are ready to take the plea, but I had emailed the police report to the wrong email address. So I believe I've corrected that this morning. So I think we just need a date where we could come back.
August 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Grant Ducia
Ashley Feltus for the people.
for Duche.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Doucet. Mr. Doucet, state your name for the record, please.
Grant Matthew Duche.
I'm requesting an adjournment for global. Mr. Doucet has a couple of pending felonies. He had them on the 21st. Mr. Cook and I kind of want to see what happens there before working something out.
August 5th, 2026, 9 a.m. Bond continue. Court calls the case of the People versus Jarrell Sewell.
Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Sewell.
It's not checked in.
I attempted to reach out to my client, Your Honor. I do not know where he is.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500, 10%.
Thank you, Your Honor.
Warrant will issue immediately. Court calls the case of the people versus Robin Hessen.
Ashley Feltus for the people.
Assistant Public Defender Nicholas Buckovich on behalf of Ms. Hessen in both matters. Ms. Hessen is now approaching. Can you please state your name for the record once you get to the podium?
Robin Hessen.
At this time, Your Honor, I would be requesting an adjournment. I'm in talks with APA Cook about resolution. However, he wants to see what happens with her 14A2 matters, as I believe are set for final settlement conference in early August.
In the matter, August 5th, 2026, 9 a.m. Bond continued.
See you before you know. Okay.
Court calls the case people versus Sherman Booth.
Ashley Feltus for the people.
This is an Arabian free trial.
State your name.
Sherman Booth.
Sir, you are before the court on a misdemeanor complaint that alleges that on or about January 8th, 2026, at the location of 3599 Beach Drive in Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of malicious use of a telecommunication service. You understand those charges, sir?
Yes.
That is a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. You understand that, sir?
Yes, I do.
My first question to you is, do you wish to be represented by an attorney?
Yes.
It's a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Booth. Will waive formal reading and stand mute to the charges, please. I'll request another pretrial date.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. These charges. I'll adjourn the pretrial to August 5th, 2026, 9 a.m. Set his bond in an amount of $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior, possession of any weapons, firearms, or ammunition. You understand that, sir?
Yes, I do.
Now also, there's to be no use of any alcohol, recreational marijuana, or any illegal drug. I will also indicate that you are not to have any contact with, is it Mahej Kahala?
I have not.
You understand that you are to have no contact with that person?
Sir.
I'll be in touch with you.
I got gun license. See how this going.
Is the Beach Drive your address?
No, it isn't. That's the complainant's address where I've never been. I understand.
I will also indicate that he's not to go to the 3599 Beach Drive address.
I have not and will not.
You understand that, sir?
Yes, I do.
Oh, thank you.
Thank you.
Thank you, Your Honor.
Court calls case people versus Zachariah Haruska Dennis.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Haruska Dennis, who's approaching. Say your name, please.
Thank you.
Your Honor, we are close to resolving this case. Mr. Haruska Dennis has completed or almost completed the In Jail Down Farm program. Once he has a certificate of completion, we get that to people. And I believe this case will be dismissed. However, he was supposed to get that yesterday. The jail was on lockdown. Class was canceled. So I'm asking for one more adjournment between now and then. He should have that final class, get his certificate, and we can resolve this case.
Turn it to August 5th, 2026, 9.
Thank you.
Continue. Court calls the case People versus Dania Donovan.
Ashley Feltus for the people.
Counsel.
Hello, what's your name?
Good morning, Your Honor. Dania Donovan.
All right. And you are here on a misdemeanor complaint that alleges that on or about January 13, 2026, at the location of West Michigan Avenue near Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle while intoxicated. Do you understand the nature of that charge, ma'am?
Yes, I do.
The misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could order community service or any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes,
This
please.
is a public defender case.
Morning, Assistant Public Defender Lauren Perny on behalf of Miss Donovan. We'll wait for reading the charges, please. I'd ask for another pre-trial date.
I will adjourn this matter to August 5th, 2026, 9 a.m. Mr. Bond in this case.
Your Honor, this is an OWI with an alleged VAC of 0.102. There was no crash, and I do not believe the defendant has any criminal history. I'm requesting a SOPR link. Thank you.
Court will set the defendant's bond in the amount of a $10,000 personal cognizance bond. I will order standard conditions, including no assault behavior or possession of any weapons, firearms, and ammunition. You understand that, ma'am?
Yes.
There is to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes.
I'm also going to order defendant is to report to the Department of Community Corrections for placement on the sober link device. All right, you're to do that today. You might want to do that before you leave these premises.
Okay.
Anything further?
Nothing further.
Thank
No,
you.
Your Honor, thank you.
Court does call the case of the People versus Paul Ledford.
Ashley Feltus for the people.
Just in a row.
Counsel.
Your name, sir?
Ledford.
Mr. Ledford, you are before the court on a misdemeanor complaint that alleges that on or about March 4th, 2026, at the location of 3362 Bent Trail Drive, Pittsfield Township, Washington County, State of Michigan, that you did break and enter a premises or that you committed an illegal entry without the owner's permission. Do you understand the nature of that charge, sir?
I've never broken into any place this
You
year,
understand?
so I would not.
Understand what you're charged with in this case.
Why would I be charged with something I've never done? I'm not even supposed to be in here for the last 3 months because
All right.
disturbing the peace. I was on that side of a perimeter where there's no
Sir, I don't want you saying
installation. I never
sir, I don't want you saying anything about the case.
never did.
I need you to know whether the charges you believe are legitimate or not. I need you to understand what you're charged with.
No, I do not understand what I'm charged with.
You don't understand it, sir?
Charged with it.
Are you telling me you don't understand what you're charged with?
That's what I am.
Okay, then we'll do it this way. Sir, you are before the court on a complaint that alleges that on or about March 4th, 2026, at the location of 3362 Bent Trail Drive in Pittsfield Township, Washington County, State of Michigan, the complaint alleges that you did enter with or without breaking a house located at that address,
With no.
whether occupied or unoccupied,
Right, so you can just.
without first obtaining
in
permission
a row,
premises
and I just keep getting charged.
from the person having
for things I've
control
never done.
thereof. Do you understand now what you are charged with, sir?
No, I do not, because I was nowhere even near there. Why don't you look on the.
Doesn't matter whether or not,
Like that.
sir, you need to stop.
You need to stop charging me with charges where I was
I'm not charging you with anything. I'm letting you know what you are charged with.
like disturbing the peace when I'm way on that side.
Do you understand what you are charged with?
Yeah, I get paperwork and all this.
What I'm gonna do is I'm gonna adjourn his arraignment out. You can take him back. This is the matter's adjourned to August.
Yeah, I get
Take
paperwork.
out of here.
There's no crime. I
Get out of here. Have a great day.
You allow me my paperwork.
Court does call the case. Well, they probably are delayed.
Yes.
You're done.
Isn't Mr. Ledford up on my PCC docket?
He is, Your Honor. He's pending competency.
Yeah, okay. Should have led with that. Okay.
I didn't get a chance. I'm sorry, Your Honor.
No, it's okay. It's all right. We'll figure it out in some. Court does call the case of People versus John Smith III.
Ashley Feltus for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. John Smith, who is now approaching. Mr. Smith, can you please state your name for the record? John Smith III, Your Honor.
Thank you, sir.
Yeah, we'll be asking for an adjournment of this matter till after the 21st date. Me and Mr. Cook are working. Sorry, what?
Is a prelim or?
Yeah, the prelim and me and Mr. Cook are working towards resolution, but maybe impacted by the result of that prelim. So
I'll adjourn it to August 5th, 2026, 9 a.m. Bond will continue. Let me just, is this the only other case other than that that's holding him?
yes, this is the only other case that is holding him besides the case for prelim. He is aware of the bond amount as matter and does believe he would be able to post it if he gets released on the other case. So the other case gets dismissed. So
Okay, so, all right, that's what I was worried about. So what I would indicate that is if something happens to that case where it's disclosed, if it goes away, whatever it is, submit an order to the court for release on a PR. I'm not gonna impose.
I can certainly do that, Your Honor.
All right, thank you.
Thank you.
Court does call the case People versus Kawanda K. Thomas.
Ashley Feltus for the people.
Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Thomas. Ms. Thomas, please state your name for the record.
You want to acquire Cynthia Rose Thomas?
Thank you.
Your Honor, I'll be asking for an adjournment. We are working towards a global resolution of all her matters. She does have some cases up in the circuit court. I believe your next court date is on the 27th, correct?
Yes.
So we'd be asking for a court date after that.
Adjourn August 5th, 2026, 9 a.m. Bound continued.
Thank you, Your
Thank
Honor.
you. Court does call the cases of the People versus Matthew Wall, all three.
And Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Wallace. Mr. Wallace, state your name.
Matthew Wallace.
Thank you.
Your Honor, I am seeking an adjournment for a global resolution on Mr. Wallace's cases.
All right, I'll adjourn all of his case. Does he have anything pending anytime soon or?
I think he's before Your Honor tomorrow.
Okay,
In the circuit court, I believe I want to say the 7th, but that might not be true. The 6th? Yeah, Judge Slay.
of August.
Yes, so, or Judge Conlon. Judge Conlon's working out a release of treatment with a transitional housing plan, a more intensive kind of wraparound services for Mr. Wallace. So the public defender there and the prosecutor are all kind of working this out.
All right, so here's what I'll do. I'll adjourn this to the 5th of August, 2026, 9 a.m. I'll adjourn all of his cases. If all of that gets worked out and it's a release treatment, then submit an order to this court that matches what's happening there. And then that way we won't hold him up.
Got it. Thank you.
Okay? Thank you.
You're welcome.
Court calls the case People versus Juanina Williams.
During the pre-trial, no counsel.
All right, so.
Your name?
Nina Williams.
Janina. All right. Ma'am, you are before the court on a misdemeanor citation that alleges that on or about June 18, 2026, Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did have in your possession drug paraphernalia. You understand what you're charged with?
Yes, sir.
That is a misdemeanor punishable by up to 90 days, $500 fine plus court cost and any rehabilitative services. Do you understand that,
I
man?
do. Sure.
All right. First question I have for you is, do you wish to be represented by an attorney?
I do.
All right. This is a public defender case.
Good morning. Assistant Public Defender Lauren Perny on behalf of Miss Williams will waive formal reading and stand mute to the charges. As
Having waived formal reading, standing mute, court will enter a not guilty plea. All right.
Miss Williams is set before Your Honor on the 5th for some other misdemeanors she's already been arraigned on.
Got it.
And I would ask the court for a release to treatment on this case. Miss Williams has a number of files, both felonies, misdemeanors here, and I think misdemeanors in 15th. She has released the treatments on her felonies, so we're asking for these to follow. So if something's worked out, they don't hold her up.
Objection from
No objection.
All right. If you submit an order to the court, I'll sign off on that. Set her bond at okay. I'll set her bond in this case at a $1,000, 10% bond, so she'll get in credit all other standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. I will order, if she's released, that she's to report to community corrections for 1 time per week drug testing.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Take care. Court does call the case People versus Devon Gibson, 2 cases.
Ashley Feltus for the people.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Gibson, who is on Zoom.
Yes, Mr. Gibson, can you state your name, please?
Evan Gibson. Good morning, Your Honor.
Good morning, sir. All right, what are we doing?
Thank you, Your Honor. This was here for a status check in advance of a final conference because we were hopeful that he would be released at the probation violation hearing to look at bond. That probation violation hearing has been adjourned, so we're simply, we don't need to do anything today. We're simply requesting the same final conference date for both cases.
Your Honor, if I may speak, I don't know if that's okay.
Go ahead.
I didn't get to, my lawyer didn't come up here to speak to me, so, I didn't really get to tell him anything, but, Miss Slay, adjourned my court for the 23rd, which is in, I think 6 days or something like that. And, the plan was to, release me on the 23rd. I was wondering, I already got 2 low cash bonds for $100 each. It's not really nothing. I don't really need the time credit. You think, by any chance, I don't know, if you could give me a PR bonds on both of those cases. It's already.
Well, I'm not,
$100
sir,
bond.
hold on. I'm not gonna do that today.
Okay.
And I may not do it at all, but I'm certainly not doing it today. We'll see what happens before Judge Slay. And if your attorney believes that's appropriate and the prosecutor believes that appropriate, then certainly they know how to get to the court and submit an order.
That's correct, Your Honor, and I am in touch with the attorney on violation who I've spoken to about this dynamic.
All right.
We will request another date or else address this final
settlement conference. So I'll just continue these to the very final settlement.
Thank you, Your Honor. By the way, Mr. Drukas will be appearing for me as substitute counsel on the final settlement conference date. And these would be separate trials. They're separate incidents with separate complainants if they're both ready.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
May I ask when those final settlement conferences are? My bad, I ain't trying to be rude.
That's okay. It's August 7th. Okay, at 9 a.m.
Okay,
for your jury final settlement conference. If it goes to jury trial, it kicks over to to Monday, which would be August 10th.
okay.
Okay?
Yes, sir.
Mr. Gibson, I'll be visiting you in advance of August 7th, and we'll talk.
Yes, sir. I appreciate it.
Thank you.
Thank you. Attorney. Oh, no. Yeah. Where is she?
Yeah, it's 11.
From where? This was set at 9.
Yes, sir.
Okay, so that's it for that block.
Yes.
We'll call it up. Ms. Henderson, we'll get to you. We'll get here.
Actually, and she said that she emailed the court, she tried to call.
I know, she called the clerk's office, she emailed the court, she's still not here.
Says it was, so I gave it.
Okay, all right. Court is standing in recess. Maybe see. Court does call the case of the People versus Daniel Worth.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Warren Kearney on behalf of Mr. Worth.
Mr. Worth?
Hello, this is Daniel Worth.
Okay. Same user. You got him. All right, what are we doing?
Your Honor, I am requesting that there was a mitigation report done, but it was never sent to people. So
Okay.
I need to get that to them so they can review it and hopefully we can come to a resolution.
August 5th, 2026, 9 a.m. Bond committee.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Elise. Is it Kibalewski? Kibalewski?
Ashley Feltus for the people.
This is a rank for child counsel. Not fair.
I'll issue an order to show cause. Court calls the case People versus Aisha Parker.
Ashley Feltus for the people.
And this one, I will issue a bench warrant for the defendant's failure to appear. Alleged BAC on this.
0.08 with a single vehicle crash running off the road at 94 and 23.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000, 10%.
Thank you, Your Honor.
Warrant to issue immediately. Court calls the case People versus Michael Roseberg.
Ashley Feltus for the people.
This is a rank for child not checked in.
Roseberg. Bench warrant will issue bond 5,000, 10%. Court calls the case People versus Dean Thrush.
Ashley Feltus for the people.
Your name, sir?
Dean Thrush.
All right. Mr. Thrush, you are before the court on a misdemeanor citation that alleges that on or about June 9, 2026, the location of eastbound I-94 near Ann Arbor Saline Road in Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle without security or insurance as required under the code. Do you understand that, sir?
Yes, sir.
That is a misdemeanor punishable by up to 1 year incarceration and a fine not less than $200 nor more than $500 plus court costs. You understand that, sir?
Yes, sir.
All right. First question I have for you is, do you wish to be represented by an attorney.
Yes, sir.
This is a public defender case.
Yes, Your Honor, Assistant Public Defender Nicholas Buckovich on behalf of Mr. Fresh. At this time, Your Honor, as we wait to the charges, we'll waive any formal additional reading and we'll be standing mute.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea.
Your Honor, addressing bond, this is a non-violent traffic offense. I'll be requesting a personal reconnaissance bond.
Bond will be set in the amount of $5,000 personal recognizance, all other standard conditions, including no assaultive behavior or possession of any weapons, firearms, ammunition. Also, no alcohol, recreational marijuana, or any illegal drug. I will adjourn the pretrial in this matter. Usually this is resolved by the procuring of insurance in some way. So we'll just do August 5th, 2026, 9 a.m. All right.
Okay.
Thank you, sir.
Thank you, sir.
Thank you, Your Honor. Reach out for August.
Court calls the cases of the people versus Daryl Green.
Special focus for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Green. Your Honor, this hearing was set because Mr. Green would like to discharge the Public Defender's Office of our representation. I think Mr. Brown filed the get off the case. Frankly, I'm not sure. We did try to get in touch with Mr. Green this week. I'm not sure of, and we were unable to reach him. I'm not sure of notice, how much notice he was given. As I believe it was set after in the last week.
Right. Correct. So the notices weren't mailed out until July 9th, according to the clerk's office, for a hearing today. So that's less than a week. Part of the court's concern, just as it regards the motion itself, is that final settlement conference has already been set in these matters. So until I can hear from Mr. Green, or at least give an opportunity as to what his issue is, I'm not going to deny the motion. I'll adjourn the hearing on the motion to the 5th. Once I make my decision, we'll do that. So,
Ron, and I would ask that for final settlement conference. If I don't know who's going to be the better counsel in this case.
I would agree with you, and that's kind of the court's concern. But what I'm going to do is I'm just going to set the motion for the 5th. And then if I do permit withdrawal of counsel, then I will certainly look at those dates.
Okay.
All right.
That's thank you.
All right.
Thank you,
I'll
Honor.
adjourn. Mr. Stiller, did you say I was reasonable?
I did.
Oh.
Honor, yes.
All right, I'm done. I got it.
No, you can't quit on me.
Yeah, a lot of cases. Yes, we do. Court does call the case. People versus Michael Acuff.
Good afternoon, this is the Public Defender Lauren Perry on behalf of Mr. Acuff. I attempted to get in touch with Mr. Acuff. I wasn't able to do so. Not sure if he's on Zoom.
Michael Acuff? It's not. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court does call the case, People versus Ryan Atkins.
Kind of sort of have to sit down here.
Mr. Atkins, it's usually here, there he is.
Assistant Public Defender Lauren Kearney on behalf of Mr. Adkins. Now, Mr. Adkins said we're not able to speak, but he did send me a message saying that he has a restoration hearing date set. I believe he said at the end of August. Is that correct, Mr. Adkins? I'm sorry. Got the
Yeah,
date.
it's August. It's Friday, August 28th at 1:00.
That's your restoration hearing?
Yeah, the re-examination hearing. Yeah.
Okay, that's at the end of August. If I set it for
Well, sorry, there's been some pretrial conferences off the record.
Yeah, I saw it going across.
Mr. Adkins, because you have your date set, the prosecutor is willing to extend an offer of double parking, which means the misdemeanor would be dismissed if you admit responsibility to a civil infraction. It's a fine of $180. It doesn't go on your driving record or your criminal record. Then this case would be closed out.
I can. Yeah, I would. Might as well do that.
Yeah. Okay.
All right. Okay. You said that admission move is just real time.
Knowing Mr. Atkins, if he said no, I was going to come through that TV screen.
Yeah.
All right. I wasn't sure what answer we were getting. Anyway, Mr. Atkins, do you admit responsibility to the fact that on February 28, 2026, location of Carpenter Road in Pittsfield Township, that you did double park a motor vehicle?
Yes.
All right. Court will accept that admission to count 2. Count 1 is dismissed. How are things going for you now, Mr. Atkins?
They're going pretty good. I'm about to be discharged off probation a year early, so next month.
Next month?
Yep.
Is that that's in circuit?
Yeah, that's the courthouse downtown Ann Arbor.
All right. There is no minimum fees, right? Those are 45.
Check.
There's no minimum. All right. All right. Here's what I want to do. Fines and costs of 180. Are you working?
Yep.
Yeah.
Yeah.
I'm going to waive $90 of that. So you only have to pay $90 when you don't deserve it, but I'm going to do it for you. No. All right. When can you get that paid, Mr. Atkins?
Can you give me a couple weeks?
Get it paid before the end of August, August 31st.
Will do.
Don't forget about it.
Oh, I won't.
Otherwise, that's the last nice thing I'll do for anybody. And you'll the reason that is all blown up. All right.
Oh, I don't want to be that reason.
All right. Mr. Atkins,
Thank
take care
you.
of yourself.
You as well.
Court calls the case, People versus Deshana Andrews.
Kind of sort of behalf of Pittsfield Township.
Yeah, Assistant Public Defender Nicholas Bukovich on behalf of Ms. Andrews. Would be appearing via Zoom.
Shana Andrews. Not here.
I did speak to her last week. I know that we over the Zoom information. I was trying to do some follow up this morning. I know she is in the process of moving, which has been causing some difficulties for her. So I would ask for the consideration of an adjournment.
Mentor will issue for defendant's failure to appear, bond 5,000, 10%. Warrant issue immediately.
Mr. Young.
Court calls the case of the People versus Eltanya Barney.
And
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Bonnie, who I know is on Zoom because I see her.
You see her?
Hi, Latanya Barney.
Oh, there she is. Thank you. All right, what are we doing?
We are asking for an adjournment, Your Honor. Bonnie is in the process of working on doing the, getting all the information gathered to do a Secretary of State appeal.
To do the appeal.
Yes.
Okay. How far along is she in that process?
I believe from my conversation with her, she's still in the earlier stages of obtaining letters and other information she might say. So I would say a longer adjournment may be better to give Ms. Bonnie some extra time to get that information completed.
September 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Ms. Martin.
Thank you.
Court calls case People versus Matthew Brown.
Honor, it's so we haven't.
And Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Brown.
I'll check him.
Brown, Matthew Brown, not here. Bench warrant will issue for defendant's failure to appear. Bond $5,000, 10%. Court calls the case of the People versus Fernandez Burrus.
Honor, it's so we haven't.
Fernando Burrus.
Good afternoon. Sorry, good afternoon.
Oh, he's here.
Good afternoon, Assistant Public Defender Lauren.
Excuse me.
Okay, I got him. All right, what are we doing?
Was not able to have contact with Burris. I asked that we defender to update his contact information.
All right, sir, I need you to contact the public defender. Update your information.
Yes, Your Honor.
All right, thank you. I'll adjourn the matter to August 5th, 2026, 9 a.m. Bond continued. Court calls the case of the People versus Raymond Sindek.
Honor, it's so okay.
Assistant Public Defender Nicholas Buckovich on behalf of Mr. Spindek.
Your name?
Raymond Sendek.
Thank you.
I was unable to speak to Mr. Spindek before the day. We only have an email on file, and I sent you emails and I didn't get any response.
I kept looking, I could only find the court case, court hearing one, so.
So I'm gonna be obtaining better contact information. I'm asking for.
Turn to August 5th, 2026, 9 a.m. Thank you. Court calls the case of the People. They're requesting that I adjourn this matter.
Yes, please, Your Honor.
Custody, I can adjourn it to the 23rd.
Thank you, Your Honor.
Probable cause conference will be adjourned to July 23rd, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Tamika Slip.
That's the people.
Where is she? Oh, there she is. All right.
Good morning, Your Honor. Christina Costantino appearing with and on behalf of Ms. Schlip. Ms. Schlip, can you please state your name for the court?
My name is Tamika Joyce. Yeah, hi, Mr. Simpson.
Hello, Miss Slip. How are you?
I'm going to. I'd do better if I could go to the minor hospital. Come on.
I didn't get any of that, but okay.
I'd be better if I could go to Kalamazoo Psychiatric Hospital when I'm supposed to be.
Got it. Okay.
Your Honor, this is the date and time set for PCC. We have had some negotiations with the prosecution. At this time, we do need a brief adjournment in order to continue and hopefully finalize those negotiations.
Again.
All right. Will August 6th work for you?
Yes, Your Honor.
Okay.
Yes, Judge, that works.
All right. Miss Slip, I'm going to adjourn you out to August 6th. Okay? Let your attorneys continue to work on it.
It's
Not
not
okay?
okay. My mom is dying.
Ms. Schlip, I know this is, Ms. Schlip, I know this is difficult, but like we talked about, this is what we need to do, and hopefully this will be the last adjournment, and I will see you very soon, okay?
All right, so Ms. Slip, she's gonna come up to see you.
Can I ask you something real quick? Can you give me a court order to go to Challenger Psychiatric Hospital?
Well, that would have to, if that's appropriate, come through your attorneys to me, okay, Ms. Slip?
Okay. Well then, I forgot my therapist's name, I'm sorry. But can you try to get me put into a psych hospital?
Okay.
Yeah.
Ms. Schlip, Tamika, we'll talk more again about that when we talk next week, okay?
Are you going to the prison?
Yes, I'll come see you again. Yep.
Okay. I'm
Okay,
sorry.
Ms. Schlip,
and you get, that's okay, you get to see me then on the 6th, okay?
I'm gonna make you smile real pretty for me.
Okay, Ms. Slip. All right, you take care. Okay, hang in. Bond continue. Court does call the case. People versus Christopher Madison.
And
please.
Oh, so
We got her. Okay, go ahead.
thank you, Your Honor. Excuse me, Assistant Public Defender Natalie Pate with and on behalf of Mr. Madison in both matters. Looks like he's appearing via Zoom from the Washington County Jail.
Yes.
Mr. Madison, could you please state your name for the court?
Christopher Madison.
Thank you, sir.
Thank you, sir. Thank you, Your Honor. I was able to meet with Mr. Madison and discuss these matters with him, and I did have a conversation with Ms. Dover. At this time, Mr. Madison is asking to move forward and set both cases for preliminary examination. To my knowledge, all discovery is complete.
Would people have their witnesses available the 28th? Preliminary examination in this matter will be set for July 28th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor. And thank you, Mr. Madison.
Fine, continue. Court calls case, People versus Kaylee Hine.
Good morning, Your Honor. Alexander Hermanowski on behalf of Haley Kine.
It's good to see you outside of the little box on this.
Nice to meet you in person as well, Your Honor. Your Honor, I have had no contact with Ms. Heim. I was appointed on this case on Tuesday. I'm asking for an adjournment.
What I will do is a bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. I will not issue that bench warrant until July 21st. Give you time to see if you can find her.
You said July 21st, Your Honor?
Yes, sir.
Thank you very much.
Court calls the case, People versus Aronde Anderson.
Again, Senior Assistant Public Defender with and on Mr. Anderson.
Yes. It's one of hers. Oh, okay.
Change it.
Yeah, we're probably gonna try to move those down too. You can.
Hi, Jesse. Could we, Your Honor, have a few more minutes, please?
Okay, you want me to pass it?
Yes. please.
Yes, I'll pass this matter. And counsel, Miss. Yes, approach. Miss Gaines, can you, and Mr. Gadd, can you approach, please? Court does call the case of the people versus Ryan LaBranch.
Good morning, Your Honor. Alexander Hermanowski with and on behalf of Ryan LaBranch. Your Honor, I was just appointed on this matter on Tuesday.
You're having a good time, aren't you?
If we could just repeat what I said before.
Okay, fair enough. And I'll issue bench warrants on these bond 10,000 cash surety. I will not issue those until July 21st.
Thank you, Your Honor. Have a good day.
Is that it for you, Mr. President?
Yes, Your Honor.
All right. Court does call the case, people versus Donovan Buckner.
Assistant Public Defender Zach Vinu with and on behalf of Buckner, who approaches.
Good morning, Your Honor. My name is Donovan Buckner.
Your Honor, as to the PCC itself, we would be requesting an adjournment for further negotiations. Then I would also like to address bond appropriate.
May.
Thank you, Your Honor. So Mr. Buckner has been in custody from July 6th, so he's been in for 10 days now. I believe that
is that a result of his bond violation?
Yes, Your Honor. I believe the allegation for the bond violation was a retail fraud. My understanding is that the people have not authorized anything as of yet. So as of right now, there's nothing to admit to. So I guess we would be requesting an adjournment of the violation itself, given that there is no charge as of yet. And then I would ask to address bond when appropriate.
Go ahead. Anything?
Well, let's address on first.
All right. Well, what I will do is I will probable cause conference. I'll adjourn to. I can go the 28th or the 6th.
The 28th would be fine with us, Your Honor.
I'll adjourn this to July 28th, 2026, 9 a.m. That's a Tuesday, by the way. All right, as to bond.
Thank you, Your Honor. So as I stated, Mr. Buckner has been in custody for 10 days now. His fiancee, Heather, is in the courtroom today. She's in the front row in a wheelchair. Mr. Buckner supports Heather and is an important part of her life in helping her get to doctor's appointments and making sure that she's able to get around. She has been in a wheelchair since, was it February? So yeah, since February, Your Honor. Additionally, Your Honor, Mr. Buckner stated to me that he does have a job offer at Potbelly and that he is accepted. He stated he has until July 21st to let them know, and that if so, he can get out and he can set up an orientation. And then additionally, Your Honor, he stated that he is looking to start school again. He's going to start back up working on taking online courses at Colorado Tech. At Colorado Tech, Your Honor, his long-term goal is to become a counselor for at-risk youth. And then lastly, Your
Why wasn't he here on June 25th?
Oh, yes, Your Honor. So on June 25th, so he logged in on June 24th accidentally. And then on June 25th, his phone died. He had to go to the First Baptist Church in order to get a charger. He then called in, but it was too late. So he did then call our office and got the bench warrant recalled on June 29th, I believe. And then it was rescheduled for a PCC on this date. So he had no intentions of missing court that day. It was just that his phone died.
Why is he in custody?
He was in custody on the alleged bond violation, Your Honor. And then
retail fraud.
The alleged retail fraud, yes.
So just so that I have this all clear, he's on bench warrant status at some point, recalls the bench warrant, then picks up another potential offense.
Yes, Your Honor.
Any response from the people?
Your Honor, you have asked all of the questions that I would have answered. And so.
I'm funny that way, but go ahead.
The only thing I would add is that alleged charge here is assaultive. He has an assaultive history. And then he said the bond violation and the peer.
Motion for bond reduction is denied. Bond will continue. Thank you.
Your Honor, would you consider a tether provision? As Mr. Buckner just consider permission to speak. He would also ask permission to speak.
What?
I'm willing to go on tether just to prove that I'm not an issue. I'm not out there trying. I'm just wanting to go to work, get back to work. And that's what I've been doing since I was 14 years old.
The sequence of events are that you're before the court, don't appear. Then you go through the warrant recall process,
which I
get out, and then allegedly commit another offense.
With retail fraud, sir, I never went in and got it.
Sir, at this point, I'd advise you not to speak about the. Yep, so.
Okay, my ruling's still the same. Bond request denied. Bond will continue. Thank you.
Judge Gunner.
Court calls the case of the people versus McDigby, Kaba.
Morning, Your Honor. Edward Jukustumpy. Cop is approaching.
Good morning, Your Honor. My name is Marty. Good morning, Your Honor. My name is Marty Bay Kaba.
Your Honor, there's some video that needs to be for sure.
Adjourn the matter to August 6, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case people versus Anthony Buford.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Buford, who is on to the podium.
Your name?
Anthony Buford.
All right, what are we doing?
Your Honor, it's my understanding that we are here today for a bond violation as well as the PCC. Mr. Buford indicates to me that at the last hearing, he did admit to the violation, but it's not clear to me from.
Wow.
So then with that, we are asking if we could go to sentencing on the violation. At this time, he has been in custody. Am I talking over someone? Okay.
No. Right. Okay. Go ahead.
At this time, we are asking that the court grant him a sentence of 8 days with credit for 8 days served. Mr. Buford has indicated that he is very clear and understands how serious the no contact order is. He has learned a lot from this experience.
Didn't understand that before.
He understands very clearly how serious this is. It is my understanding that there was nothing threatening or of that nature in the calls. He has a child in common with the complainant and had just hoped to hear some words from his daughter. With that, we are asking that you sentence him to this time because, again, he understands that this is very serious, that he must abide by the no contact order, that there are no exceptions for contacting her in order to contact his daughter. If the court sees fit for any alternative for him to contact his daughter, then he, of course, would appreciate that. But if there is not an alternative, then he will just not have any contact and focus on other things, such as he does have a job, which he was able to speak to and be assured that they would hold it open for him a little while longer. In addition, he has family support. He's been in communication with his mom, and he indicates, and he did last time, he did appear in court in person, and he will continue to appear in court. So we are asking that Your Honor consider that. He is very apologetic, and again, is very clear about the serious nature of court orders and that he must follow them. Is that correct, sir?
That is correct, no.
Anything from the people?
I'll leave it in the court's discretion. My only concern is that these calls were made from other states, not his own parents. So I'm concerned that he's trying to hide the fact that he's calling the victim by not then given the nature of his regulation, I took concerns for her safety, given that he violated his privilege act.
I'll sentence the defendant in this case on the bond violations. You said he's been in 8 days,
Yes, Your Honor.
sentenced him to 10 days, credit 8 days. For violation, then his bond is his previous bond is then reinstated with its conditions. You understand that, young man?
Yes, Your Honor.
So don't come back here, be hearing any contact whatsoever. Or you'll sit in jail. Am I clear?
Clear, Your Honor.
All right, what am I doing with the case?
We'd like to set it for a preliminary exam, please.
Your Honor, in regards to the bond, was there a Jupiter study provision?
There should have been initially a GPS tether division, I thought. Were you on a tether?
Yes.
Sir.
I'm sorry.
Tether will be reinstated.
Thank you, Your Honor.
And so all of your discovery is complete, Ms. Gaines?
Yes, that's my understanding.
And the people have their witnesses available the 28th. Preliminary examination in this matter will be set for July 28th, 2026 at it's gonna be noon, right? At 12 noon before me.
12 noon. Thank you, Your Honor.
Thank you. Court calls case, People versus Nayeli.
People.
Good morning again, Your Honor. Christina Costantino appearing with and on behalf of Nia Lee. Ms. Lee, can you please unmute and state your name for the court?
Nia Lee.
Okay, there she is. All right.
Your Honor, there is a companion case that this case is tracking that is at the circuit court. There's a pretrial in that matter scheduled for July 27th. So we would be asking for an adjournment of the pretrial to a date after that date.
I don't have that, so I'll adjourn the matter, the PCC to August 6, 2026, 9 a.m.
Thank you very much, Judge. I appreciate it.
Thank you.
Thank you. The court calls case, People versus Aaron Burrows.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burrows, who should be approaching. Mr. Burrows, can you please state your name?
Aaron Burrows.
All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant will be pleading to count 3 and an added count 4. Count 3 being the operational motor vehicle without security, the 1-year offense, and the added count 4 of use of a controlled substance, a 1-year offense. Upon a successful no contest plea to those charges, counts 1 and 2 would then be dismissed. That's the court's full understanding of the agreement.
Your Honor, that is our understanding of the offer as well. And no contest plea, and we did submit that police report to the court on Monday.
I thought I read. All right. May I have him sworn?
Right ahead. You solemnly swear affirm the testimony you're about to give will be that's the truth self.
I do.
State your name, please.
Aaron Burrows.
Sir, it is this court's understanding that you are going to be pleading to 2 misdemeanor charges. Is that your understanding?
That's correct.
First of all, to the stated count 3 of operating a motor vehicle without security, that's a misdemeanor punishable by up to 1 year incarceration, a minimum $200 to $500 fine plus court costs. You understand that?
I do.
And also an added count 4 of use of a controlled substance, that's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
I do.
All right. Do you understand what a no contest plea is?
Yes.
All right, 2 things about it I have to make sure that you understand. First of all, it means that you're not further desirous and wanting to contest these charges. You understand that?
I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You understand that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Barr at the 1482 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Fear of civil liability, Your Honor.
Third to the charge of operating a motor vehicle without security, how do you plead?
No contest.
To the charge of use of a controlled substance, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
All right, you signed an advice of rights form or had it signed on your behalf.
Yes, I did.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as other rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily and of your own free will?
Yes.
All right. Court has been provided and has reviewed Michigan Department of State Police report for their case number 548-6. Any objection to the court reviewing that report?
No objection.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I have to advise you that between the time of my acceptance of your pleas and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I do understand, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court law?
Satisfied, Your Honor.
Court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered. 14A2 probation. Sentencing will be the township. We have different sentencing here.
Yes.
Belly. So, yeah. So it's been with the information. Here it is. That's it.
Motion. July 28th at 10 a.m.
July 28th, 2026, 10 a.m.
Yes, sir.
10 a.m. before Judge Barr. Bond continued.
Your Honor, as to bond, we are also here for a bond violation.
We are?
We are.
Okay, go ahead.
As to that, Your Honor, my client has been in for 21 days on the violation as of today. He would admit to the violation. He is the sole provider for his mother. However, she is very ill and needs medications. She needs those at proper intervals as well. Mr. Burrows had placed himself into Don Farms after the initiation of this case on his own accord, but had to leave due to his mother falling, unfortunately. He'd also been in the hospital himself for several medical issues. He's asking for release with home confinement, any testing provisions that the court would deem appropriate to ensure compliance. We would just be asking for an opportunity for him to be out on bond prior to sentencing so that he can handle the pre-sentence investigation, interview, and also to begin taking care of his mother again.
But he didn't go over to community correction.
I don't think he went on time initially, Your Honor, and at that point, when he did go, I believe there was a diluted test for a positive.
Well, there was a positive test for cocaine and amphetamine.
That's my understanding as well.
Response from the people.
I believe it is in court's discretion. It sounds like we have all of the legend plan for the just if you speak on for June and for
So how do I know he's going to come back? I did see that.
Well, Your Honor, I imagine that a GPS tracking tether would certainly help in that. Also, the simple fact of the matter is that you just informed my client. My client understands that he has a lot to lose between now and the time of sentencing were he to violate. So I imagine that that might be incentive enough for him to come back. I think at this point, he just wants to handle it.
What's it?
All right, the defendant having admitted to the violation. Will sentence the defendant to 21 days jail, credit 21 served.
Okay. Good.
Previous bond with its conditions, including community corrections reporting, is reinstated. Defendant also will be placed on the GPS tracking tether. Thank you.
Thank you, Your Honor.
Court calls case versus Faith Askew.
Michael Gaddy is a defender on behalf of Ms. Askew. She be here by Zoom too.
Askew,
Yes,
all right, states the game.
Faith Askew.
All right. What are we doing?
Your Honor, I have a green sheet if I may.
Yes.
Your Honor, I'm asking for a brief adjournment. I have had an opportunity to discuss this matter with Ms. and Mr. Kennedy. I think we may be able to work something out. I'd ask for the briefest of adjournment so we can try and do that.
No. Probable cause conference will be adjourned to August 6, 2026, 9 a.m. Bond continues.
Thank you, Judge. That's
Court calls the cases of the people versus Michael McLean.
Christina Sachs on behalf of Michael McLean.
And Assistant Public Defender Natalie Pay also on behalf of Mr. McLean and the cases ending in 1395 and 5530, Your Honor.
All right. Requesting an adjournment.
I am, Your Honor. Yes, I apologize, Your Honor. We all are, and here's the form.
All right. Okay. I have the 28th or the 6th. Which would you prefer?
28th would be fine, Your Honor. Thank you.
28th. That's a Tuesday. I'll adjourn these matters then to July 28th, 2026, 90.
Thank you, Your Honor. Thank you, Your Honor.
Court calls the case people versus Laura Bart.
We're going to go to the seat, Your Honor.
Your Honor, Michael Gaddy, Assistant Public Defender, Bard, who should be here by now.
Ms. Bart, can you unmute and state your name, please?
Laura Bart.
Thank you. What are we doing?
Your Honor, I'm asking for an adjournment. We'll have me an offer. I would like to discuss it further with Ms. Parks.
I'll adjourn it to August 13th, 2026, 9 a.m.
Thank you.
I'll be in touch, Ms. Parks.
Court does call the cases of the people versus Janina Williams.
The people.
Good morning, Your Honor. Assistant Public Defender on behalf of Janina Williams on 26F10069 and 26F5558.
Good morning, Judge Christopher Quinn, P69483, appearing on behalf of Ms. Williams on the other case.
All right. What are we doing?
Your Honor, we would like to set the courtroom.
Mr. Quinn, what are you doing on your case?
We would also like to set an exam, Judge.
All right. Preliminary examination in these matters. Discoveries complete in both cases.
I believe so, yes.
Yes, Judge.
People have their witnesses available the 28th.
I'm checking all three cases right now, Your Honor.
All right.
We'll do our best.
Preliminary examination will be set July 28th, 2026 at
Judge Fresh Hour.
9 a.m. before Judge Fresh Hour. Thank you.
Thank you.
Thank you.
Court does call the case People versus Maurice Boyd.
As well as with people.
Matter Michael Gaddy, Assistant Public Defender on behalf of Mr. Boyd.
Sir, if you can unmute and state your name, please.
Maurice Deshaun Boyd.
Thank you.
I just need to fill it up. Your Honor, I'm asking for an adjournment so I can discuss this matter further with the people, and also we're trying to look for any potential recovery court out county, outside of Washtenaw County.
Adjourn the matter to August 13th, 2000.
What would you do if one mistake kept pulling you back into court? This courtroom session was packed with emotional moments, but one hearing stood out above the rest. A defendant asked the judge for another chance, explaining that he wanted to return to work, support his fiancée who depends on a wheelchair, and get his life back on track. His attorney argued that he had a job waiting, plans to return to school, and hopes of becoming a counselor for at-risk youth. But the judge wasn't convinced. Looking at the defendant's history, the judge pointed out a pattern that couldn't be ignored: a missed court appearance, a recalled bench warrant, and then another alleged offense while already under court supervision. When the defendant insisted he wasn't causing problems, the judge cut him off and refused to lower his bond. Later in the session, another defendant admitted violating a no-contact order just to hear his daughter's voice. The judge acknowledged the apology, but made one thing crystal clear: court orders are not optional. He sentenced the defendant to jail time and warned that any future contact would send him straight back behind bars. The hearing served as a reminder that judges may listen to personal struggles, but accountability always comes first. Every decision in court carries consequences, and trust has to be earned, not requested. Do you think these judges made the right calls, or should they have shown more leniency? Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more real courtroom moments.